right. Good afternoon, everybody. We will go ahead and get started since 1 hour and about 13 minutes from now we can then go have a cocktail. So, or maybe that's not 13 minutes, like 25 minutes. Anyway, sorry, my math was wrong. Yeah. All right, so this is the panel on social consumption. So just as soon as we thought we had everything figured out with marijuana regulation and enforcement, social consumption comes along and threw us for a loop. So we've got a panel together today of some Denver folks, and then we have Erica McConnell, the director of the Alcohol and Marijuana Control Office from the state of Alaska, here to talk about Alaska's challenges and what's on the horizon for Alaska in regards to social consumption. And then Ashley Kilroy, the director of Excise and Licenses for Denver, Marley Brodowski with the City Attorney's Office, and myself, I'm Molly Duplashane, the Deputy Director with the Denver Office of Excise and Licenses, and we will tell you all about Initiative 300, which is Denver's social consumption initiative that we are currently implementing. So I will first hand it off to Ashley. Oh, no, I did this last time too. Yeah. I will hand it off to Erica.
Thank you very much. My name is Erica McConnell. As Molly said, I'm the director of the Alcohol and Marijuana Control Office for the state of Alaska. In Alaska, marijuana is regulated by a Marijuana Control Board, which is a 5-member board that is appointed by the governor, and they are all volunteers. In our state, as I expect in all of yours, if you even haven't heard about it yet, I'm sure you'll hear about it soon, there's been a push for social consumption. The reasons that we here in Alaska, the number one reason we hear about is tourism. Alaska, we get a lot of tourist visits, which is great, and what we hear is that tourists need a place to consume marijuana because some of them are interested in trying that when they come to our state. Other reasons, at least one of which was mentioned this morning, is like in Colorado, in our state, property owners do have the right to forbid marijuana consumption on their property. So you may have renters who don't have a place to consume, and then you may also have people who have children who don't want to consume at home with their children, but still would wish to consume at a different time. This is what I need. There we go. So, what does Alaska law say about social consumption? Well, we have a very different approach from the city of Denver. So, state statute 1738 is our section. Oh. Thank you. 1738 is our section in our state statutes that governs our commercial marijuana. Oh, and I should also say, Alaska doesn't differentiate between medical marijuana and retail marijuana. While we have had a medical registry in state law since the very late 90s, we never created a system of medical grows or dispensaries. So when our ballot measure passed in the fall of 2014 to allow recreational, retail, commercial marijuana, we didn't have an existing medical system to build on. So when our regulations were written, we just have marijuana, and we treat patients who are looking for marijuana for treatment of their ills, and a recreational consumer who just wants it for fun, they are treated exactly the same way. So keeping that in mind, our state law says that it is unlawful to consume marijuana in public, and there's a fine for that. However, in the regulations, which are at 3 AAC 306, which are developed and adopted by the Marijuana Control Board, they define in public and they exempt an area on the premises of a licensed retail marijuana store designated for on-site consumption. So you may ask, well, how do they get to carve out this business from being in public like every other business to allow for what we call on-site consumption? And the hidden key is in another part of state statute, 1738-121, where it says that a power and duty of the board, of our Marijuana Control Board, includes the board's ability to reduce a licensed premise area if necessary, to ensure control over the sale and consumption of marijuana on the premises. So our legal department says that shows that there was an intent for the board to be able to set regulations regarding on-site consumption of marijuana, even though the statute says it's unlawful to consume marijuana in public. So in case you've walked into this thinking, oh yeah, this is an easy issue and it'll be dealt with really simply, I want to disabuse you of that notion right away. We have been struggling with this issue for a year and a half. The board originally started a regulations project in February of 2016 to set regulations for on-site consumption. They looked at, so our regulations process, probably like in many of your states, requires a certain amount of public comment period. And so so every time there's significant amendments, it has to go back out for more public comment. So they looked at 3 different drafts over from February 2016 to February 2017, and then they killed that project. They said, nope, we're not ready to do this. We're concerned about being the first people out of the gate. We know that Denver is looking at this. We understand that the state of Maine is looking at this. So we're going to wait. Okay, well, a month later, they said, no, we're going to look at this again. We're going to open a new project. So they opened another project, and so now we're doing it again. So we are smack in the middle of a process. The board did have a draft at their July meeting of this year, which they made a bunch of amendments to, and it's out for public comment, and our comment period closes October, I think it's the 27th. It's either the 27th or the 29th, and they'll be looking at this again at their November board meeting. So the biggest issue, there's a whole bunch of issues which I'm going to talk through in 2 slides, but I just wanted to say that the biggest issue that we hear about is about indoor clean air. The state of Alaska does not have a statewide indoor clean air regulation. So smoking indoors is not banned throughout the entire state. And not all local governments have health powers to enable them to enact some legislation at the local level should they wish to. But some of them do, and so an example at the municipality of Anchorage, which is the largest city in the state of Alaska, they do ban smoking indoors in all places of employment with 2 exceptions. One is that a hotel is allowed to set a certain number of their rooms as smoking rooms, and 2, clubs that are not places of employment are allowed to have smoking, and that was kind of a carve-out for some cigar clubs. So as long as it was sort of an all-volunteer situation with no employees, that you were allowed to do smoking there. But again, recall this indoor clean air issue is really just about the smoking of marijuana and doesn't have anything to do with edibles. There's no ban on consumption of edibles in hotel rooms. So one of the things that we struggle with is how do we mesh the state regulations that are going to permit on-site consumption at retail stores with local governments that have banned smoking indoors. So the board is wrestling or working through or has determined on a lot of these issues. And so I put local control as the first because they're still trying to work out, can a local government just ban on-site consumption altogether? So the way it would work is that you would have a retail store, and then a retail store could get an endorsement to have an on-site consumption area. So can a local government just straight out ban on-site consumption endorsements? So they're fine with having the retail stores, but they don't want the on-site consumption. Or are they only going to be allowed to just opt out of having an on-site consumption area that allows smoking and then only allow the consumption of edibles? But then the other local control issue is that they are allowed to protest individual applications for particular reasons. So that's some clarity that needs to be provided in our regulations. Other issues that they are working on, appropriate ventilation, and again, the ventilation does relate to the smoking issue. So if there isn't going to be smoking, there's not the need for ventilation. But if there is, what's appropriate ventilation? These regulations would not allow, so you would have to buy your marijuana that you're going to consume in the on-site consumption area at the retail store that has the endorsement for that area. So how are we going to control this? How are we going to prevent somebody from bringing in marijuana that they grew at their home or that they bought at another store into, are they going to be frisking people and checking their pockets and bags to make sure that they don't have a joint tucked in their pocket from some other place? And that also relates to purchase limits. So we have purchase limits for purchasing and walking out to go take to your house, but we have lower purchase limits for on-site consumption. So are they going to set up the, 2 different point of sales so that they're clear that if you're purchasing for on-site consumption, your limits are lower? I mean, they haven't really figured that out yet either. They are proposing not to allow concentrates, so no vaping or dabbing, that you would just be able to do smoking or edibles. I think another big issue that they're not going to be able to solve, because I think we haven't solved it yet scientifically, is the issue of impaired driving, and how do we know when somebody is too impaired to drive? And that relates to overconsumption and being impaired on the premises. Our marijuana regulations are modeled on our alcohol regulations, which say, you can't have a person who's impaired on the premises. Well, how do we measure impairment? So that's a big issue. No employee consumption, separate employee monitoring area so that there aren't any effects of secondhand smoke. No happy hours or specials pricing or anything like that. What to do with unconsumed marijuana. Originally, they were going to say that if you bought more marijuana than you were actually desiring to consume at that particular time, you would have to leave whatever you didn't use behind and it would be destroyed. They've now turned it into, okay, you can get it as long as you have it packaged in the same way that you would have to package something you purchased to take away, child resistant, opaque, et cetera, then you could take any unconsumed marijuana off-site with you. How would we allow a consumption area in a separate structure? They started at the last meeting, they were talking about, well, what if you have a little shed out in the back and that's where you want to have your on-site consumption area? So, how's that going to work? How's that going to be allowed? And that has to relate to all of our monitoring requirements, video coverage and that sort of thing, and when you have people going back and forth between 2 different buildings. Is there going to be consumption areas that are outdoors? If it's allowed outdoors, a smoking patio or something like that, what are the rules around that going to be? So that's actually something that's not addressed at all in the current draft, so that'll be something they have to look at. And they are not allowing the sale or use of tobacco or alcohol in the store, in the on-site consumption area. So these are the issues that the board is wrestling with as they walk and talk through their draft. One other issue that I didn't list here, and that it isn't really something the board is worried about, but my enforcement staff is very concerned about this because they don't particularly want to go into a smoke-filled room to do inspections and enforcement. So they're concerned about kind of protecting their own health and safety if marijuana is something that they don't choose to use. So those are it's all the details that I have about what we're doing in Alaska, and I'd be happy to answer questions later during the question period or at any time during the conference. Thank you.
So interesting, all of the issues that Erica mentioned are the same things that we've been struggling with as well, and some of the things that have slowed us down in doing this. First, you'll see from Amendment 64, the timeline for us is with Amendment 64 that was voted by the voters in 2012. It didn't specifically provide for marijuana clubs. It said nothing in this section shall permit consumption that is conducted openly and publicly or in a manner that endangers other. So it sort of left it open. It said nothing's going to prohibit it, nothing permits it, but also nothing would prohibit it except our current laws. And so that left it up to us to see if there was something that we wanted to do about it. And if you think about it too, I mean, if the proponents, they could have put in there, in addition to the 4 type of licenses that we already have for retail sales, for grows, for infused marijuana manufacturers, and testing facilities, they could have put another license in. They could have had a fifth license that voters would have voted for, which could have provided for marijuana consumption, but they didn't. So we were sort of stuck in this gray area. After it passed, then we started having these conversations about what should we do about social consumption. Pretty quickly after it passed, the mayor asked me and Molly and Marley to start working on it and thinking about it. At the same time, at the state level, a bunch of legislators took up this issue and were looking at it. What we found over those couple of years until it was voted on in favor of in 2016 is that it was very, very, very hard to build consensus. Some of the things, there are multiple bills at the state level, and one of them was like what Erica's talking about for having sort of tasting rooms attached to licensed facilities. And I think that was proposed at the state legislature all 3 years, and every year that failed to get out of committee. There are also other variations. At the city level, Molly and Marley and I started having multiple meetings with a bunch of stakeholders, including other business entities in our neighborhoods and marijuana businesses and marijuana activists, sort of asking that question, do we want to do this? And if so, what does it look like? And we were even having a hard time getting out of the gate, should Denver do this or not? And then if we do, what should it look like? So while we were doing all that, citizens were getting together and, petitioning and going forward with initiated ordinances. In 2016, this one passed, but in 2016, there had also been another one, which they pulled from the ballot, and in 2015 had been another model. But in 2016, Initiative 300 passed, and that allowed for individuals to apply for a permit to get a consumption area, designated consumption area at their business or for a special event. So what is I-300? A quick summary of it. The purpose is to allow people to get a DCA, to get a permit for a DCA, designated consumption area. Because it's not in a licensed facility, it has to be BYOC, because nobody else can sell. If they were selling at that business, that would be distribution. It can be permanent or temporary, including outdoors. So we could have somebody could have a permit for a DCA in their yoga shop. That's just a permanent year-round permit that they would come to Denver to excise and license to get the permit. Or somebody might have it for one Sunday of every month. So a special events type permit. It also doesn't require specific zoning permits. So, and I use the example of yoga shops and a yoga studio because that's one that the proponents have thrown out and which we have seen some interest in it. If the yoga studio is zoned appropriately, then they can get the permit. There's no additional zoning requirements. Unlike our other marijuana laws, in the initiated ordinance that the voters voted in favor of, the only area restriction is it has to be 1,000 feet from schools. They're allowed to operate same hours of bars between 7 and 2, and the permit is valid for a year. One of the things the proponents put in the ordinance was the application to even get in the door at excise and licenses, the application has to have evidence of community support. So as some of you may know, when you have liquor licensing, on the back end, once you get the application in and your application is QC'd, you have to have a needs and desires hearing on the back end. What the proponents put in the ordinance is even to get in the door, even for excise and license to accept their application, they have to have evidence of support or non-opposition from the community. So that's sort of a hurdle that some of these businesses are now struggling with to get that right out of the gate before they've even sort of gotten their business model together. The other thing that was in the ordinance, it also said outdoor smoking at ground level cannot be viewable by the public or from a place where children congregate. And then the basic things of licensing, you must provide proof of possession, a criminal background check, and a couple of other things they put in there was like this responsible operations plan, a waste disposal plan, and they had a couple, I think it was a 9-page ordinance, Molly? So the ordinance itself that our voters voted on had a lot of parameters and restrictions in it already. They also set the permit and application fees. They'll later be set by council, but they're a $1,000 annual licensing fee and a $1,000 application fee. So our goals as we were going forward was to do this like we've tried to do everything else. to implement this new law responsibly, making sure we're listening to our neighbors and meeting all the needs and desires of all of our community members. Of all the marijuana bills that have come before Denver in the last maybe 7 years or 10 years, everyone has passed by a pretty large margin, pretty wide margin. Amendment 64 passed by 66% in Denver. Statewide, I think it was about 55%. This one for social consumption passed by 53%, Molly, right? And so it was a pretty close vote. So we really decided that we really needed to hear from everybody and make sure we got it right for Denver. The other thing that we were struggling with from the get-go was here we have this initiated ordinance that arguably conflicts with some of the fundamental bases of our law. And the first one is we have an initiated ordinance that provides for social consumption, right, socially and in a business. And then we have a city and state law that says public consumption is not allowed. One of the things the initiated ordinance did when it passed this, at the same time, voting on that, struck the city open and public prohibition. So we didn't have the city law, it exempted these social consumption, designated consumption areas from our prohibition on open and public consumption. So the city law on open and public consumption did not apply to this, so it was okay under our city law, but these conflicted with the state prohibition on open and public consumption. So as we went through that, their ordinance said it can't be viewable, from a public place or from a place where children congregate. That was one way where we sort of, got to restricting it, keeping it from being open and public, but we still had other issues to address. Another issue that we had to look at right away was the state prohibited marijuana consumption on liquor licensed premises. And so that was one thing that the proponents said that they had in mind sort of from the beginning. They wanted to be able to do this maybe at a restaurant, maybe at a club or a bar or a concert venue, and state law prohibits marijuana consumption on liquor licensed premises. Even though state law, and actually the proponents are challenging that at the state level, but in Denver, we also believe that is part of our values, and we've also put that in our rules that address this. We also, regardless of what the state law is saying, our rules also say this cannot occur on a liquor licensed premise. The other issue we had was the Colorado Clean Indoor Act. The Colorado Clean Indoor Act obviously prohibits smoking indoors unless there's an exemption if you have less than 3 employees. But that means people could still, vape or have edibles. So that was another thing when maybe the proponents were thinking this would be more like a club where people would be smoking marijuana, which they tell us that is the preferred way to consume marijuana, is smoking it when we don't allow indoor consumption. They felt like we were thwarting the intent of the ordinance. So let's see. Oh, and then the one other thing, we have the federal rules, the federal guidelines. The federal rules, Cole Memorandum, Ogden Memorandum say that states and local jurisdictions that have marijuana laws have to have strict rules and robust enforcement in order for the feds to make this one of their lowest enforcement priorities. So with all of that background, we've got, the limitations that were already in the ordinance, that the proponents drafted and our voters voted on. We had all the other balancing act to do with state and federal law and our current existing laws. We put together this working group, and Molly will talk to you a little bit about it. But before we get there, we'll talk about some of the ideas that we heard from people in these working groups. So first, we always heard about the yoga studio, that they wanted to have, maybe Friday marijuana consumption night because it was indoors. That could only be vaping and edibles because of the Colorado Clean Indoor Act. We heard from someone who had a coffee shop, and that was going to be one of their major things that they were going to be doing, just like they do in Amsterdam and The Hague. So they would have a coffee shop, and they would have a permit for full-time, and if they have an outdoor patio that is compliant with the Colorado Clean Indoor Act, then that would be permissible. We had individuals talk to us about a craft studio, having classes and periodic smoking outside. So they do the crafts inside and then go outdoors to consume marijuana. We also have a couple of tourism companies who wanted to, do maybe a special event warehouse where they'd have the warehouse, maybe do a party bus and take them from one warehouse to the other. And because it's indoors, it would be smoking or edibles. Another thing that came up, that whole piece around restaurants and bars, we talked to the Colorado Liquor Enforcement Division, and they said that yes, we could allow, or they would allow, marijuana consumption on a liquor licensed business, like a restaurant or bar, if that restaurant or bar delicensed their business for that evening, for that time. And what apparently this happens with restaurants, like or bar, if they rent it out for a wedding and you want to serve your own alcohol, they'll delicense and take all their liquor and put it somewhere into one little closet that's licensed, and then you can serve your wine or whatever you want at your own private party. Same thing for a marijuana consumption night. Maybe a restaurant or a bar that's not that busy on a Sunday night could delicense and have marijuana consumption that night. One of the things to remember under this model, because they're not selling marijuana, it's not really an economic development type model. They can charge a cover fee, but it's really, and I think that's another thing that people who are interested in getting into this are starting to see, that it's hard to figure out how you make money with this if you're not serving alcohol, you're not selling alcohol, you're not selling the marijuana. So there's a couple others there for you to look at. One that we're getting some traction on that looks good is an arcade. Sort of an arcade type. Apparently millennials like their video games, so they would do an arcade and let people bring their own weed and smoke. The other one that I always liked was when we had our work group, somebody was talking about, he had a glass blowing studio, and they use those big blow torches, and that would just work out just great with smoking weed and blow torches, because you could light your marijuana. So after that, Molly decided we would ban all torches in our designated consumption areas. So anyway, those are just some examples of what we've heard to get your mind around what we were struggling with as Molly went forward leading the committee.
Okay, based on what Ashley just has talked about, this was the information that we had. We knew that Initiative 300 had passed, but by a relatively small margin. We knew we had some conflicting laws in some areas, whether it was the federal law or some state or even local laws. And we had these list of ideas that had been bounced around. And so after it passed in November, we quickly pulled together our Social Consumption Advisory Committee in December of 2016, so just about a year ago. And we met twice a month for 3 months. We had 6 sessions. The purpose was to provide suggestions and feedbacks to build rules and regulations to implement the ordinance. So the ordinance language did allow for rules and regulations to be adopted as a responsibility of the Department of Excise and Licenses, which required a public hearing and a public process. So we pulled together that committee. This is just a quick list of all the committee members. We wanted to be very intentional and strategic and thoughtful and diverse in our advisory committee that we pulled together. So we had representatives from the community. We had representatives from public health, from the school districts. We had legal representatives, our city attorneys, as well as an outside legal expert. We had industry representatives, both from the marijuana industry, even though they weren't necessarily going to be involved since this was a bring your own model. But we also had people that were event planners or people that owned businesses that were interested in getting one of these licenses. We also had the proponents of the campaign as well as the opponents of the campaign. So we had a very diverse advisory group. We have one of our members, Aubrey Lavazos, who's here today, and he was represented on our advisory committee as well. And so we made sure that this was a very public and transparent process. All of the agendas were online 1 week before the meeting occurred, and all of the minutes were online 1 week after the meeting occurred. We tried to establish some pretty good ground rules as this committee was established. We wanted to make it very clear that it was an advisory committee and that the rules in the end were adopted by the Department of Excise and Licenses, but we really wanted the feedback and the input from all of these stakeholders since this was, once again, something new that Denver was taking on with no roadmap. We really wanted to bring in everybody's voice and feedback and make sure that all of their concerns and goals and values were heard as we entered into these conversations. So we reviewed and we discussed options for all the different areas of concerns and all the different challenges. We had a list of topics that we developed based on the language that was in the initiated ordinance. So we looked at this language that was in the ordinance. We looked at all of Denver's existing rules and regulations, state laws governing retail and medical marijuana. We took language from the Cole memo and we looked at that. And we looked at other laws and regulations that we had that governed liquor. We really were just kind of looking for anything that we could use to start with a foundation or some kind of base to make some comparisons as we established what these rules and regulations were going to look like. And we wanted to give the advisory committee a menu of options. And so it wasn't that every option that we threw out there was necessarily going to be put into the rules, but we wanted to make sure that we had a very thoughtful and in-depth conversation about each of the topics and each of the possibilities and each of the options for all the rules and regulations. So as we built out our agendas, this was just an example of some of the agenda topics that we went through. And when Marley goes through what the actual rules ended up being like, you'll see that much of these did translate into rules that were adopted. So we talked about proximity restrictions. We have proximity restrictions for marijuana businesses. Did we want proximity and distance restrictions also for the consumption areas and location restrictions? There's a list of unlawful acts that were in the initiated ordinance. So did we want to add to that, or did we need anything to support what was already in there? Different types of application and operational requirements. There was the requirement to have a letter of community support as a part of the application. And did we need anything in the rules to kind of define what that meant or define how the department would accept a letter of community support? As Ashley said, we had a really in-depth conversation about dual consumption, the consumption of alcohol and marijuana on the same premise. And there was a lot of strong values in the committee about what that looked like. And then we talked about restrictions on access. So this was one that was pretty difficult too. And this was going back to finding that balance with that prohibition or state laws around public consumption. So how do we have consumption in businesses that are public without it being public consumption? And then we talked about public hearings, and in the ordinance, there's a whole separate language around special events. And so did we need to come up with different rules and regulations for how special event permits would work? As I said, we tried to make it a very public process. The meetings were open to the public. We had time reserved at every meeting to allow for members to provide, or for members of the public to provide comments. And then we had a separate meeting, a public hearing at the end where we reviewed all of the rules and regulations. And again, we offered public comment. I think at that hearing, we had about over 60 people come and provide public comment. And this is just an example of how we built the agendas for each meeting. We tried to be very organized and very transparent in how we were building the agendas. And so, as an example, what we did was we listed out what language we had to guide us from the initiated ordinance. So what's listed here is that the consumption area had to be 1,000 feet from a school. And then we looked at what other restrictions or what other comparable rules are out there for other types of marijuana businesses. So other marijuana businesses have to be 1,000 feet from an alcohol and drug treatment facility. They have to be 1,000 feet from a child care establishment, and they have to be 1,000 feet from another retail marijuana store or a medical marijuana center. So we had the conversation with the advisory group. this is what's out there for other marijuana businesses. Do we want to take that same language and adopt it for consumption areas? And then we looked at other things that were prohibited by law, around the no liquor license premises allowing marijuana consumption and marijuana businesses not allowing on-site consumption. And then we just opened it up for other suggestions, whether that was, did we want to look at other schools or childcare establishments, or we talked about not having that 1,000 feet restriction from other retail marijuana businesses, so that they could allow for purchase of the marijuana and then not have to go so far away to be able to actually consume it. So after we had these 3 months of process, it took us about 6 weeks to finally develop and draft those rules and regulations, and then we held that public hearing in June. And then another couple of weeks later, we adopted those final rules and regulations, which Marley will be going over.
So I think you're getting a flavor for why nobody wanted to do this first. Yeah, I know I'm showing my age a little bit when I say, you know, let Mikey eat it. He'll eat it. He'll eat anything. So it's kind of let Denver do it. So here we are, and we've done it. And honestly, I want to, you've already kind of gotten a flavor for what Ashley and Molly put together, but I really want to sing a tribute to them, and I see Aubrey nodding in the audience, that putting this group together and being very thoughtful about the members and being very thoughtful about how they structured it was critical to the success of the committee. It wouldn't have been at all as productive and result in some great rules and regulations that make sense and that aren't crippling to an ability of a business to get one of these permits without their thoughtfulness. So as you can see, we were trying to thread some needles. The biggest needle from my point of view, from a legal point of view, was the open and public consumption of marijuana. It's prohibited on the local level, the open and public consumption. It's prohibited on the state level, and then it's also addressed in Amendment 64. So we were trying to thread that needle to not violate local ordinance, not violate state law, and have the AG suing us or something like that. And so we had to really think about that. In the ordinance itself, it excluded these designated consumption areas from the definition of openly. So there's a definition of the open consumption of marijuana, but there's also a provision in our ordinance and in state law. Our ordinance is modeled after state law for the public consumption of marijuana, and these weren't exempted from that definition. So we still had that needle to thread. So one of the things that was going on at the same time as this committee was meeting was a couple of things going on at the state legislature, but one of the things was an attempt to try to put some more definition to what publicly meant. And what they were almost got really, really close to passing at the state level was, it means that the public has access to that location without restriction. And so that was very helpful to us as we thought through, okay, can we do this without violating state law? Can we make it so these locations are accessible to a group of people, but there are enough restrictions that we're not violating that public consumption portion of both local and ordinance or state law, if that makes sense. And so what we thought about was, okay, what kind of restrictions can we put on these that would kind of get us around it being too public? And so already in the ordinance was they could only be accessible to people aged 21 and over, so that's a restriction. So it's not open to the general public at large. There's a restriction on age. In addition to that, we put some additional restrictions where the doorways into these areas had to be constantly monitored. So constant monitoring, and that also every person who entered the area had to have their ID checked. Not just if you look a certain age or older, everybody who went in had to have their ID checked. So they don't seem like huge restrictions, but there are some restrictions on access that got us around that public difficulty. There were also some signage requirements that were already in the ordinance about that the access is restricted to to people aged 21 and over. We imposed some additional signage requirements. The outside of any business that might have we're calling them DCA, designated consumption areas, that might have a DCA inside of it has to have a standardized placard. We kind of stole ours from wherever the Netherlands is sitting in here. We stole ours from Amsterdam, and it looks a lot like the one from Amsterdam for their coffee shops. But every business, brick and mortar business that has a DCA inside of it has to have that placard on the outside of it to let people know, yes, there's a DCA area inside, and then a person can make an educated decision about whether to enter. Within the ordinance also, there was a prohibition about outside smoking, that could not be visible to the public from a public right-of-way or a place where children congregate. We added the prohibition that any marijuana consumption could not be visible to the public from a public place. So those were all of the rules that we imposed kind of to add the restriction for public consumption. All right, so the next kind of thread or needle that we were trying to thread was the dual consumption issue. When I-300 passed, I believe right when it passed, there were no state or local laws about liquor and marijuana dual consumption. There had been rulemaking going on at the state level during all of this, unrelated to the I-300 working its way through the voting process. There had been rulemaking going on at the state level, and right after I-300 passed, this rule went into effect at the state level that said anyone who has a liquor license cannot allow marijuana consumption on the liquor license premises. So that pretty much cut off a lot of the places that the proponents had anticipated would be able to get these kinds of permits. In addition to that, though, we had very animated discussion in our committee meeting, like Molly was talking about dual consumption, and people have very strong feelings about that. We had some very strong concerns about it with kind of the policy decision points that Ashley was talking about impaired driving, about the effects of dual consumption, that they really impact the impairment level of a person. And so there was a lot of talk about the dual consumption piece. So we added in our own rules, in addition to what the state did for state liquor licenses, we added our own rules that you could not permit the consumption of alcohol within a DCA. I think Ashley kind of touched on the other nuances of the liquor license, but as of right now, liquor and marijuana cannot be consumed together in a DCA in Denver. So in I-300, the ordinance itself requires neighborhood approval. It actually calls its neighborhood approval has to be submitted with the application, but neighborhood approval can be a letter of support or a letter of non-opposition. So I'm not necessarily supporting your DCA, I'm just saying I don't oppose you, and that's good enough under the ordinance. Because of a lot of the work that was done at the committee level, we decided that the neighborhood needed a little bit more input on these, and we imposed in our rules that there's a public hearing requirement for the brick and mortar businesses. So it's what we commonly call a needs and desires hearing in the liquor world. Does the surrounding neighborhood need and desire this DCA to be located in the neighborhood? There's also a public health, welfare, and safety component to that hearing. Special event permits don't have an automatic hearing. They will have a hearing if 10 signatures are submitted from neighbors within the designated area. And then again, the signage piece it will be there as well. So the public hearing piece, the fact that we really wanted our neighborhoods to be involved in these decisions factored into the public hearing part. And the proximity restriction, so in I-300 itself was the 1,000-foot restriction from schools. We looked at, as Molly talked about, we looked at what restrictions we have for other marijuana businesses. We imposed all of those, 1,000 feet from a child care center, 1,000 feet from a drug rehab center, and then what we did add that doesn't apply to other marijuana businesses is 1,000 feet from city-owned recreation centers and outdoor pools. The other piece In the ordinance itself, it talks about that the owner of a property can withhold consent to have a DCA on the property or a DCA special event on the property. So we decided that these special events could not be located on public property or city-owned property since we were the owners. Unlawful acts section. I think this was touched on, that the marijuana consumption could not occur in a marijuana licensed business. That would have to take a state legislature action to make that happen. So we couldn't do that. So it can't occur on a marijuana licensed business. So you can't sell it, you can't buy it in there, there could be no distribution in there. There was a lot of talk about, okay, can we share it? Can we share a joint or not? Is that distribution? And so we didn't drill down that far, but it's still a BYOC kind of a model. But we didn't prohibit sharing a joint. The unlawful to allow butane torches was not because of the glass blowing example. Funnily enough, it was actually brought up and suggested by the industry itself, and they talked a lot about using butane torches for actually lighting their marijuana. And so we just wrote that in there because nobody opposed it and they had suggested it. So, and actually our fire department supported that. You know, you've heard a lot of talk today throughout all the sessions about our problems with butane anyway, and some of the explosions that have gone on, and we just really didn't want to go down that road with these kinds of licensed facilities. And then it's unlawful for any owner or employee to be consuming marijuana while they're working. And so Ashley touched on the Cole memo. We're really always, anything we do here in Denver is guided by the Cole memo. We take those 8 priorities very seriously. State law, the compliance with the Colorado Clean Indoor Air Act. Ours is a little bit more robust than what Alaska has. It is allowed on places of employment that have 3 or fewer employees. But other than that, it would be prohibited at an indoor location. The ordinance had the responsible operations plan, the health and sanitation plan. We added some advertising restrictions. In Denver, you cannot advertise any other licensed marijuana business in a public place where it's visible to the public. So if the public can see your billboard from a sidewalk, that's not allowed in Denver. And we really hammer down on that and are very strict about that. We just made that exactly consistent with all other marijuana businesses. They can advertise on the business, they can't advertise on billboards or anything else. They can advertise on the radio, they can advertise on the internet or in magazines with certain restrictions, but public advertising is restricted in Denver. We also imposed a waste plan. We didn't want a bunch of half-used joints thrown into a dumpster. And I don't know if this has been talked about at any of your other sessions, we have a certain level of a problem with dumpster diving anyway for marijuana waste here in Denver, and we didn't really want to add to that problem. The odor control plan, we added on to that, which is consistent with the odor control plan that's required for grows and manufacturing facilities here in Denver. And then they also had to comply with any other permitting requirements in the city. So as Molly just talked about, we adopted rules in June. We finally started taking opened applications up in August. We have yet to receive any, although we have had several meetings with folks with really, really creative ideas, kind of exciting ideas, frankly. I hadn't thought about some of them, and Ashley touched on them. This will automatically sunset in 2020. It's a pilot program, so it will automatically sunset in that year unless City Council takes measures to do something else. But we'll see. We are kind of in a holding pattern at this point, so that's where we are.
So I think we are open to questions if anybody has anything. Brandon?
I have lots of questions.
So do we.
I'll limit it to two. One is for City of Denver. You had mentioned that there's a $1,000 application fee and a $1,000 yearly license fee. Does that apply also to a temporary event that may just take place for, just say, like a day, something like that?
Yes, it does. That was written into the ordinance by the proponents, so that's what's in there. Yep.
Okay.
Got that.
And then the second question was, you had mentioned some additional buffer considerations for social consumption locations. Is there like a map where folks can go and take a peek to see where it would be appropriate and inappropriate to cite?
We have a map available. We haven't put it out on our website or anything, but we may have given it to people on request. It's not an interactive map, so you can't zoom in on your location or anything like that, but it's more of a map to just give you an idea of how much space is out there. We require that applicants sign a distance waiver. It's really on the responsibility of the applicant to do that due diligence to make sure that their location meets the distance restrictions. Do you have anything to add on that, Marley?
Oh, sorry.
Do you have anything to add on that, Marley, the distance stuff? No. Okay.
Can I ask one more? So Oregon's Indoor Clean Air Act is a little different from Colorado's. Oregon's does not allow for vaporization. I'm wondering, is it your sense, is there any political support at the state level here in Colorado to include vaporization in the Indoor Clean Air Act, or is that ship kind of already sailed?
Vaping is not included in the Colorado Clean Indoor Air Act at all, and there was some discussion in our committee about that. I wouldn't be surprised if somebody puts that forward in the next legislative session. It was a topic of concern for some folks, but I haven't heard anything recently.
We did have a couple of members advocate to exclude, to put into our local rules that vaping should be excluded from these areas.
Thank you.
Good afternoon. Thank you for your time. I have 3 questions. Piggyback off of his, do you foresee a reduction in the different buffer zones? For example, some of your buffer zones are from building to building or from property line to property line, or they vary like crows, like a straight line or radius. So over time, do you think, and it differs between the schools or health buildings or something like that. So over time, do you foresee a reduction in those building codes? I'm sorry, in the distances that you guys have already set?
Can I just clarify one thing? So we did have, what she's talking about is how it's a measurement made. And in our first, the Denver Medical Marijuana Code and the Denver Retail Marijuana Code, there were some differences when it was a child care center versus whether it was a school, whether you measured in a straight line or as pedestrian access. We changed all of that last spring. It's all straight line now.
Okay.
Just to clarify on that.
Okay, perfect.
But I'll let.
We haven't had any conversation specific to consumption areas. It's so new that we're going to let it play out a little while until we make any changes. And there has not been any push or proposals or anything to make any changes to our proximity restrictions for other types of marijuana businesses.
Okay. Second question, you have an exemption in there for less than 3 employees on the premises. Is that a hard employee line, or does it leave room to distinguish between an employee and an independent contractor?
That exemption is from the Colorado Clean Indoor Air Act, so it is a state that law that says you're exempt from the Colorado Clean Indoor Air Act if you have 3 or fewer employees.
It's state statute, and we have no control over it. And
Okay.
it includes contract employees and volunteers.
And volunteers, okay. And
Marley, let me ask too, and it's whether or not they're working that night or not, right?
Yep.
So you could have only one person working that night, but if you have 3 or more employees, it still would still have to comply with the Colorado Clean Indoor Act.
Gotcha, okay. And my last question is, how do you plan on making sure restaurants comply with their ability to get a temporary license to allow people to come on site to consume marijuana, but they have to put away their alcohol? How are you going to make sure they comply with that? No, not allowing people to have access to that alcohol. Because there's some restaurants have a full liquor shelf. They have several shelves, maybe 5 or 6 shelves of liquor, and that's a lot of bottles to move. So how do you plan on making sure restaurants comply with that?
I was looking around for the Denver police.
Well, I think, so from my point of view, I mean, what we do is we're always monitoring and have a good idea of what's going on in the community, whether it is a illegal club popping up or some other activity, and our police officers are watching it, we're monitoring the advertisements for those type of things, and then if it's something that we think might violate law, most of the time we will reach out to them affirmatively and say, you know, this event that you're planning would violate this law or that law or this law and could jeopardize your liquor license. Most of the time when we've affirmatively reached out to people, then maybe they weren't even aware of it and they will not go forward. But then when they do intend to go forward, we do send people in and we enforce.
Reinforce it,
Yeah.
okay. Do you, I'm sorry, piggyback, are you working with the organizations that have to give buy-in for the social consumption to be a DCA? Are they a part of the compliance in keeping those businesses compliant as well?
So
Are they
Like the
part of
community, the
process?
neighborhood organizations that, no, I don't, I mean, they could submit complaints or something like
But that's
that, but they wouldn't be in
probably
charge
about
of the
it.
enforcement, yeah.
Okay.
But I would add two things around the enforcement. The first is that they have to submit an operations plan. And so they'll have to have, if they're going to be delicensing an area of their premise from liquor, they would have to include in their operations plan how they're going to do that, how they're going to control that.
Okay.
And my second point is that enforcement, I think, will be a whole new challenge since we haven't had anybody apply or had any of these open yet. We don't have a whole lot of answers around that, but the enforcement will be a whole new challenge that maybe we'll focus on at the 2018 symposium.
Thank you, ladies.
And great questions, because like I said, all we have right now are those little bubbles of ideas. We don't know how it will play out.
Hi, so I'm hoping I can get you all to address advertising a little bit more, since I don't see anything specific to advertising on the agenda. What has your experience been regulating the advertising of marijuana in particular, and specifically with regard to the U.S. Supreme Court's decision in Reed a couple years ago? How has that impacted, if at all, regulation of marijuana advertising?
Probably best for Marlene.
So I touched on this a little bit, thanks for the question. I touched on this a little bit. The Denver law mirrors state law to some extent, where in this, the piece that we are very strict about is that advertising can't be visible to the public from a public place. And again, if we always go back to those Cole Memo priorities, and the number one priority on the Cole Memo was access to children, and the visibility of advertising to children is very, very impressive on them, or impressionable on children. And so we see billboards sometimes, not often, but we are very, you know, we're not looking to shut businesses down, but we make sure they understand what the law is and they get the billboard down. With regard to Reed, we've done a lot of research on this, and because marijuana is federally illegal still, the First Amendment is, applications are different, and we feel comfortable in how we're enforcing our advertising restrictions.
I can add briefly to that. So our advertising restrictions for our on-site area would of course be kind of combined with our retail store advertisement restrictions, and we are currently revisiting those because we did very kind of generic and pretty basic advertising restrictions that just apply to the retail licensees, and so we're finding that product manufacturers and even cultivators are doing advertising kind of willy-nilly without the same restrictions that retail stores have. So we are not only revisiting our advertising regulations to make them apply to all of our license types, but also to be more responsive to the various methods of advertising: signs, publications, radio, television, flyers, internet, that sort of thing. Some of our advertising, like one of our rules says you can't advertise within 1,000 feet of a school. Well, if you have an ad in a magazine and the magazine has a place where it's distributed that's within 1,000 feet of a school, well, is that a violation or not? So we have a lot, we need to put a lot more detail into these rules to be more targeted to the various types of advertising. So something we're looking at.
I had a question about the education and training of the employees in these venues. What was that discussion like? Is there a certification required? If so, could you describe that a little bit? Second, for outdoor events, I know that you can't do it in public view, but there would potentially be outdoor venues that would not be. Do you have special rules around that? And I'm also sort of thinking of not events that promote cannabis consumption, but every concert I've ever been to in 25 years is people are smoking weed. So how does that work? Thanks.
So in Alaska, all licensees, employees, and agents are required to have a handler permit issued by the state of Alaska. And before they can get a handler permit, they have to go through an approved education course. And the board approves the courses, but the courses are given by private vendors. And so the courses are supposed to have a component related to impairment and evaluating impairment. And that was one of the reasons that I mentioned having a separate employee area for the employees to monitor, so that the employees are not, assuming there is smoking, the employees are not standing in the smoke-filled room becoming impaired and monitoring other people who may be becoming impaired. So that, you know, you get this kind of weird, the employee's going to stand behind a glass, you know, window staring at people who are, it's kind of odd, but I don't, you know, that seems to be what the board is contemplating. So that seems to be where we're heading.
We did have one of the committee members on our committee who is a business owner who owns some great restaurants in town, who ultimately wants to get one of these permits, and he really did argue in favor of employees being allowed to consume while their customers are consuming. And we had another robust conversation about that, which Aubrey was intimately involved, and the group decided against that. And so we say the employees cannot be consuming, and they have to undergo TIPS training and training to be able to recognize intoxication.
And if you'll just tell us what concerts you're going to, we'll send our agent.
And we do have the can't be viewable from the public to the public from a public space for outdoor special events too. So we had conversations around that, around can it be in a tent, and the fire department will not allow for it to be in a tent. But they'll have to have, you know, like that green screening or something from their area to make it not viewable to the public from a public place. So we've heard interesting ideas around that. Think tiny homes, or what are those, like storage?
Shipping crates.
Shipping crates.
Or just like a private parking lot. You know, like somebody gave the example of a private parking lot, which is next door to a bar. You'd have to have the private parking, you know, have to have that green screening around it so it couldn't be visible from a public place, but people could walk out of that, go next door, get their beer, drink a beer, come back. But we just figured, you know, we wanted to do what we could do, but we couldn't really regulate against every, you know, possible opportunity somebody would have to mix alcohol and marijuana. And also just getting back on that, one of the reasons why we really felt strongly about, and I guess Molly said it too, about alcohol and marijuana is because what CDPHE, our Colorado Department of Health, is very clear on that right now we still do not know completely what the full effects are of dual consumption. We know that it exacerbates intoxicating effects of either, but we don't know to what extent or what that really winds up being. We all have had, or not all of us, but we have experience as a nation, maybe regulating alcohol and understanding how much alcohol somebody might be impaired with, but we don't right now. We couldn't even really do the TIPS training on it for a bartender or someone to understand where somebody could be overserved. So that's why we were pretty strict on the dual consumption piece. So, Wendy?
Hi, I've got two questions. One is about the advertisement. I heard you say it was allowed on the internet. In Holland, it's not allowed, and we are discussing whether the internet is a public place where we as a government have a responsibility or not. Some people say we do and some people say we don't. But until we have a solution to it, we don't allow advertisement online because it's very, it could be very available for youth playing games and stuff on the internet. And the other question I have, maybe you said something about it, but then I missed it. Why do you separate the selling and the social use so strict?
Can you repeat the second question?
Well, in Holland, the coffee shops, they sell and they have a special area, a special place where people can smoke as well. And then why Denver is choosing not to allow it?
Well, that would have had to have been done at state law, at the state level, because right now the state issues the licenses and state law says you can't consume on a marijuana licensed premise. So that was one of the things we started with out of the gate, that we couldn't have a DCA in a licensed business. But the state has looked at that, like I said, sort of in that context of maybe a tasting room. The state has looked at it, but that just hasn't, I think they've looked at it the last 2 years, but that hasn't gotten anywhere yet. And then on the advertisement on the internet?
As far as internet advertising, so again, we just copied for DCAs, we copied the exact same advertising restrictions that we already have, I don't know if this is on or not, that we already have for our other marijuana businesses in Denver. We, in Denver, do not regulate internet advertising or any of that because it's done at the state level. And in the state rule, I'm pointing over there because I see you. At the state level, if you want to have an advertisement for marijuana business on a website, you have to have, and I'm not sure what the language is, but reasonable proof that only 30% of your audience is under the age of 21. Is that a rough estimate of what that is? So that's a state law right now for other marijuana businesses. We don't regulate it on the local level.
Thank you.
Me again. I know it's only been a short time since you've had the applications available, but do you have a sense of why no one has applied yet? Is it just because it's so soon, or are there particular barriers that people have expressed to you to meeting those qualifications? I'm just curious if you've heard anything about that.
Yeah, and thanks for raising that. We probably should have affirmatively raised it. The proponents of the initiative, right after we passed the rules, and some of them had been on the committee and had agreed to the rules, right after we passed them, they came out publicly saying that they thought the rules were too strict, that we had passed rules that there wouldn't be an opportunity for people to open these type of businesses, and that the work group and us had intentionally thwarted the initiative. And we completely disagree with that. As I said from the very beginning, there were a lot of requirements around these businesses, even to get up and running, whether it was from the federal government, the state law, where we had that line to walk, and the things that Marley said, we threaded the needle. And there's a lot of requirements put in place by the initiative itself. So right now, I think what they've narrowed in on is they believe that we've put so many distance restrictions in that there's not enough places for these to go. But as we look at the maps and we look at them closely, there's enough, there's significant areas. And what we've heard from people is, number one, they're working on getting funding. Number two, they haven't sort of figured out what their business model will be, because remember that it has to be a consumption area in an existing business. So people who want this consumption area have to figure out, well, what's my business going to be? Oh, I'll have a coffee shop, or I'll have an arcade or something. People have told us they found locations, but they're now working on community support. So I think also when we had our public hearing, we had a bunch of different people chime in and talk about what was going on. And one woman talked about just opening a daycare and said how long that took her to do that. By the time she had to learn all the rules and the regulations and get the property and go through the zoning and everything, it took a while. So we're going to be monitoring it carefully, and we're out here offering to people who are trying to apply. We will help walk them through the process. We've already been meeting probably with about 8 different, or maybe a dozen different groups about kind of where they are in the process. And we're trying to sort of track that information of what is slowing them down, what is thwarting them. So we'll be tracking that, and if we're seeing something that's been too strict and we need to loosen up, we can do that. But if we've also seen that we've been too lenient, we can tighten up if we need to do that. But we'll be reviewing it on an ongoing basis.
One thing is that the ordinance language said that it was for a business or event to create an area for consumption. And so some of the places that we've talked to have to first establish their underlying business. And so I do know there have been a couple of places that have submitted applications for license to establish that underlying business, whether that's an entertainment facility like an amusement facility like an arcade, or a restaurant or eating and drinking establishment or something like that. So they're kind of at the first step in the process, and then they would come in and submit their actual permit for the consumption area.
Thanks. Two quick questions for you. Where do you draw the line on what a marijuana business is? So is a media company that focuses on the marijuana industry a marijuana business, or does it, where do you draw that line? And two, as a group, where do you hope this goes, or what are you hoping to accomplish by offering social consumption?
So the first one's easy. So where do we draw the line on a marijuana business is we consider when we talk about a marijuana business, that's talking about a licensed marijuana business. And in Colorado, there's only 4 types of licenses: license for selling, growing, manufacturing, and testing. So right, a media company or an event organizer who's organizing marijuana tours would not constitute a marijuana business and doesn't have the same advertising restrictions. So where do we hope social consumption will go? That's a tougher question. I mean, I think the first thing, one of the things that the proponents campaigned on was that they hoped that by having social consumption, we would get people off of the streets consuming marijuana. To the extent we have issues with with public consumption outdoors, that we'd get more people indoors. And other than that is to, implement the will of the voters and make sure, we're balancing the needs and desires of everyone else, and that we're doing it in a way that keeps our communities safe. And, the same reason why we had the diverse work group that we had, that we kind of listened to all voices, and maybe Aubrey would be, maybe on the next speaker, Aubrey, you could come up and kind of tell from your point of view what you sort of hope to get from these social consumption businesses.
Has there been a significant increase in legal issues with social consumption?
I guess that sort of depends. The data is hard to look at because if the police go out and do a sweep, we'll get a lot of social consumption, a lot of public consumption tickets. And if they're not doing a sweep, we don't get a lot of public consumption tickets. Anecdotally, the first year or two, we got a lot of complaints from community members about people consuming on the streets, consuming downtown, and consuming in our parks. As time went on, we looked at how we could do a survey of that, and we had some real challenges, even hiring a professional surveyor to sort of survey what's the level of public consumption and has it increased. Over a period of time, we quit getting as many complaints. And then we sort of didn't know, well, are people not complaining because they're tired of complaining and they're thinking nothing's happening? One of the things we did when we legalized marijuana is our council made public consumption a non-criminal violation. So it's just like a parking ticket. So we don't really know, but we're hoping that to the extent we do have that public consumption problem, that this will help alleviate that to some extent. Yeah.
Hi, I was thinking that if people want to share social consumption of marijuana, why don't they just form a private club, sort of like the Kiwanis model, or maybe this would be closer to the frat boy model? But I mean, I can see other kinds of social sort of tribalism things coming up from that, but surely this has come up before, and I wonder if you have any thoughts about that, anyone on the panel?
Yeah.
So yeah, there's this public-private. What is public and what is private? And then that's a difficult question. Are you the law professor from? No. Okay. I heard a law professor earlier today.
I'm a professor, not of law.
It's a difficult analysis to do from a legal perspective as far as what truly is a private and what's actually public and trying to look private. And we've had a lot of folks try to figure that out and find the sweet spot for that. So we run into it all the time. Some folks aren't getting it, aren't truly. If you just pay a cover under the case law, if you just pay a cover charge to get into a bar, that doesn't make the bar private. It's not a private club now just because you had to pay to get in. It takes a little bit more to make it into a private type of a party. So we've had people try to figure out what that means, and they continue to do that.
But I think like what you're saying, if it really is a purely private club, like a Kiwanis club, or like well, I don't know about it, but a really purely private club, that's private, and they could have marijuana consumption there, and they don't need a permit to do it. So that's always been out there, but the struggle we have is the way people make money is not really through a purely private club. It's through having events, and once they're advertising it on Facebook, or once they're charging a cover, or whatever they're doing, then it kind of crosses that line, is it really private to public?
And I think it comes back to the question before about what are we hoping for, or what are we trying to solve for? And if one of the things that we're trying to solve for, or that somebody's trying to solve for, is tourists being able to go somewhere to consume, how does somebody in from out of town legitimately join a private club for a day?
And we have seen clubs that allow people to join for a day, which claim to be private, but really are public. Yeah.
I have a question. What about the marijuana buses that take folks around and they smoke marijuana on these buses? How does that work? How does that fall under this?
Well, they are legal. Marley?
There's an exception in our public, there's an exception for limos for hire. And so we haven't really drilled down into it. We've written lots of memos as far as what, we have a lot of them around Denver. I know you've seen them around Denver. They're operating under a loophole in our public consumption laws for alcohol that were just kind of translated over into marijuana. And so right now they're illegal.
Now, in state law, does it say you can't consume in a moving vehicle, right? So are these not considered, in terms of definition, a moving vehicle?
So if you're in your own vehicle, you can't consume in your own vehicle, but you can consume in this limo for hire.
So not his car, right?
Not
If
in
I'm in the
his
back
car.
seat.
Yeah.
Or my Uber driver, but if it's a private rented limo or
Right, like-
bus situation. Okay.
So yesterday, I was in visiting a dispensary, and they provided me with a little piece of paper that told me of cannabis-friendly places that I could go to consume. I'm from California. They knew that when I checked in. And I was thinking, is that something they do as a good business practice because that particular dispensary is good about it, or is that something that you guys mandate? And then they also had some literature available about safe consumption, dosing limits, start slow. Same question, is that something they're mandated? And then who drafts that information and publishes those little flyers?
Yeah. Well, that's great to hear they're distributing that. We do, I don't know if you saw the red Know the Law cards. Those are some from the very beginning that we've had in the dispensaries that they've given out. And that's just sort of really, that was from the very beginning, very basic. Know the law, it's illegal to drive high, illegal to consume in public, illegal to give to minors. So those were some basics. Then the industry took it upon themselves and did the next pamphlets, which were eat slow, start slow, go low, go
Start
low.
slow, go slow.
Something like that. Yeah, and then they did that one. And then I'm glad to hear, I didn't know about the ones about where we can consume legally. We talked with the industry about, once we got the DCAs passed, that we'd help them draft something that kind of explained the DCAs. But we haven't mandated any of that. I think that's just good business practices on their part. Yeah. Thank you.
Hi there. I'd like to know a little bit more about your odor control plan. First of all, what do you guys use to measure the odor? And second of all, what sort of methods or techniques can somebody who's requested a social consumption license, what can they do to eliminate that odor? Because as we all kind of know, when you're smoking a joint or even a cigarette, the smoke just kind of goes where it wants. So I'd just like to hear a little bit more about that.
So yeah, we had interesting conversations about odor control during our advisory committee as well, specific to the outdoor locations. And so how our odor control plans work for, all of our stores and grows have to submit odor control plans too. And the way that those work is that you submit a plan to our environmental quality division, and they review that plan to make sure it'll be sufficient based on the size of your grow, or how much they give you some kind of recommendations as far as what type of odor control plan you would need, or they give you feedback as to whether your plan will be approved or not. So we're anticipating this would be the same as that. You would submit a plan, and the Environmental Quality Division will review that plan and determine whether they think it will be sufficient or not. As far as how it will be measured, I think it'll be complaint-based mostly, right? We do have some technology available, but it's not anything that is very reliable or that we have ever used to issue citations.
And I know grow odor is different from smoking a joint odor. And how do you keep it from going all over the place when you're outside? When we were in committee, I don't know if you guys remember this, there was a gentleman who had cards already made about this invention he had for a table, and it immediately vacuumed the smoke down into the table. People are coming up with things. Someone else came up with a green wall idea where you surround it with like a 9-foot tall trellis with plant material on it that would absorb the smoke. Those are a couple ideas that came out at committee.
Yeah, it's really on behalf of the business owner to come up with a plan, and then the city will approve it, but we don't have any recommendations for a business that's going to be having outdoor smoking right now. So it'll be one of those lessons learned as we go forward.
Hi, Sarah Tone from Washoe County, and I'm wondering if you can share your inspiration for developing your framework for going through this decision-making process, not only for the public, the elected officials, but also your internal team. I'm noticing that's one of your successes, and I'm looking for additional reading on it. So,
I will give Ashley credit for the inspiration. I mean, we just knew it had to be a transparent and clear process so that we could be successful in the end. And it really was Ashley's idea to lay out the agendas to be able to show what was already in ordinance, what were some comparable rules we could look at, and to open up the discussion that way.
And I think another thing that was really important was having the minutes and having the agendas released ahead of time, and then everything put back into the minutes, and then asking people at the next meeting, is there anything else? Because when we got through it and we got to the very end, and it's happened in almost every single public process we've gone through, you know, somebody's not happy at the end, and they're saying, you didn't do this, or you didn't listen to me, or whatever, and we had it all in the minutes, and we could point back. It still didn't totally satisfy them, and I get it if people change their mind, but at least it made us be able to point to where we had made the decisions and why we'd made the decisions we made. So, and it was Molly, it wasn't me, to tell you the truth.
It was a team effort. I also forgot to mention too, we had a facilitator at our meetings who has a really great system where she brings these index cards and she puts them up on the wall, and she basically had the agenda already written out in index cards up on the wall, and then as people would come up with ideas or as we'd have these conversations, she would add index cards to the wall. I meant to actually include a picture of it in my slideshow, and we can put it on the one we put online, but it was a really helpful process for people to be able to see how their ideas were being included. And I thought of something else too, but that was helpful too.
All right, so we've got 7 more minutes for questions, or we can go to happy hour early. Yeah. All righty.